Thank you, Ms. Reilly. Justice Manmohan, Justice Chawla, Justice Menon, Mr. Batra, I'm sure we'll have a very interesting session because it's a very interesting topic. ARB-Med, and of course, added to it is ARB-Med, ARB and Med-ARB. Now, the interesting thing about this particular topic is that it contemplates a dispute resolution mechanism which has both the impact of mediation as well as adjudication. Well, mediation, as you are all aware, is a process where you encourage the parties to eventually resolve their disputes. The mediator per se does not adjudicate the disputes in any manner. Arbitration, on the other hand, is an adjudicatory process where the parties really don't participate in the decision-making process. So this is a dispute resolution mechanism which actually combines both. It combines the benefits of parties deciding to resolve the disputes themselves, and to the extent that it remains unresolved, you can then proceed on a process of adjudication. Interestingly, if you notice, both the mediation as well as arbitration are really, in one sense, have a significant amount of party autonomy. Like one of the professors in Boston had said, even in arbitration, it's like consummated romance. It rests on consent. So this is really, in one sense, both these processes are very consensual, where parties have a very significant participation. And I was just thinking of where all has this kind of experimentation done. And one of the jurisdiction that comes straight away to mind is oppression and mismanagement. I had now, oppression is a very interesting jurisdiction because oppression is that if affairs of a company are being managed perfectly legally and there is nobody has fallen foul of the law, yet it is oppressive to one particular party, he has a recourse to a legal remedy for oppression. And that time it used to be Company Law Board, now it's the National Company Law Tribunal. But essentially, oppression is an interesting jurisdiction for this particular purpose, because you may be perfectly right and yet you could then approach the Company Law Board or the NCLT for recourse for resolution of the disputes. Now, if everything is going on legally and yet there is oppression, then obviously the answer really is to encourage the parties to resolve it first. So strictly speaking, if one looks at the judicial process in oppression, it was quite akin to what we are now talking about, Med-ARB. The first overture of the Company Law Board or NCLT now is to really see whether the parties can resolve the disputes themselves, basically because they are really joined at the hip, being at the shareholders of the same company. We all know that bulk of the companies in India, small companies in India, are family-owned companies, even some of the larger ones. So if you look at it, each family member or each family group normally has some shares. And the moment the alignment in the family changes, and you have a majority on one side and minority on the other side, a majority could always continue to run the affairs of the company perfectly legally and in accordance with all statutes, but at the same time being very oppressive to the minority shareholders. They could practically be excluded from the affairs of the company because it's a majority rule. Now, in a situation like this, the only answer to remedy it would be to either get the minority shares out of the way, buy them out, and remove them from the company. The other option is to get them together and work out a working relationship. And of course, the final option would be to simply wind up the company, which is obviously not palatable to anybody. So this process of first trying to resolve and then taking the next step to adjudicate is intrinsic in this jurisdiction. And if you can just review the judgments that have come over the years, you would find that each of the judgments starts by saying how the parties, what the equations were, how they were brought together, and then of course the legal issues. So, this is the first thing that came to my mind to point out that MEDAB is really is an efficient way, system of resolution of disputes when one looks at how effectively it's been done in that jurisdiction. Well, I think that is really in sense what I had to say, but I leave it to my colleagues to add to that.